So, to start then, what it's obviously really important to appreciate is that the key parties in your governance structure are your trustees and members. Now, your trustees may be referred to as charity trustees. You may talk about them within your school as directors. Sometimes you may simply refer to them as governors. They're all essentially the same. It's the same person, but they can be referred to in many different ways. But just so you have a clear idea as to what that means in practice, it is very important that you clearly understand that members and trustees have different roles. So what I will flag up to you is that for an independent school in particular, it may be the case that members and trustees are effectively the same people. That's, however, not always the case. Say, for example, for academies, and certainly traditionally, the members and trustees could be entirely separate individuals. Now the position is that the DfE recommends that within an academy, there should be a separation. So the majority of members should not be trustees. That's to basically allow a level of oversight. But that's something that is important to bear in mind, particularly if you're thinking of reviewing your charity structure. Another point that I would just like to flag up at this stage is that you may be aware, and this relates to academies, there is a recent change that has been brought in for members, and this is set out in the Academies Financial Handbook. So within the Academies Financial Handbook, what it states is that from the 1st of March of this year, no members of your trust can be employees. Now that's important because that's not what always used to be the case, and it may be that your articles of association don't reflect that. If they don't reflect that, the requirement is now for your school to make those changes. So what I'm going to do now is move on to a slide that we have on members to talk through the roles in particular of members within your school. Now, members, of course, play a crucial role in safeguarding governance. So your members should assure themselves that your trustees are acting in accordance with your school's charitable object. Now, in some schools, your members may need to ensure that the religious character of your school is also preserved. That could be a function, obviously, with some schools where you've got historical links, perhaps with a diocesan board. A key point to remember is that your members, however, should not be involved in the day-to-day business of your school, but their role is to use their powers to step in if governance is failing. Now, for your members, what it's always really important is to go back to your specific articles of association for your school. So that's always a good starting point. But generally, what you'll find is that your members may have the power to appoint new members, also in certain circumstances to remove existing members. Other powers of your members may be to appoint perhaps trustees, and we may also expect to see a power to remove serving trustees. Your members should have the power to amend your articles of association, also to appoint your school's auditors, and to receive, but not to sign, your school's annual audited accounts. Your members may also change the name of your school and could ultimately wind up your charitable company. So that is within the members' power. Now, moving on to the next slide to look at the role specifically of trustees within your school. So the Board of Trustees is the key decision maker. Now, trustees may delegate operational matters to senior leaders and or to committees, but it's important to remember that your board always remains accountable for all decisions that are made. Now, the Board of Trustees must operate and take decisions in line with your school's charitable object. So obviously not at all in accordance with your individual trustees' own interests or on the basis of anybody, the views of anybody that appointed them. Decisions must be taken that are in the best interest of your school. So stepping back just to look at who are the trustees likely to be in your school? What would we expect to see as a matter of good practice? Well, in an academy, what we would usually see is that trustees may perhaps be appointed by a body such as a foundation or a diocese. They could be appointed by members. They may be elected by parents. The principal of an academy could also be a trustee. However, although the Articles of Association, the model articles as drafted, currently allow for other members of staff to be trustees, the DfE's clear preference now is that no other members of staff shall be trustees. Now, in an independent school, to some extent it's similar. So you may see, for example, parents as trustees. You could see people with a local connection to the area that your school's in. There could, again, be appointments made perhaps by a religious body. There could be former pupils. But what we would not expect to see is that the headmaster or any other staff are trustees at an independent school. And that's effectively to avoid any conflicts. What I will move on to now is something that hopefully you're all aware, that the Charity Commission has published 6 key duties for trustees. Now, it's important to be aware of these and to always think about them and have them in the background, because these duties always will help you, will help your trustees to comply with your legal duties. So the first duty for your trustees is to ensure that your school is carrying out the purposes from which it's been set up and no other purpose. So you're focusing on your school's charitable object. Now, the second duty is to always ensure that your trustees comply with your own governance document, with any charity law requirements and other relevant laws. So this really is it's getting back to basics. It's making sure that everyone on your governing body fully understands your own governing document. So that's obviously the key. That's the starting point. That sets out procedures that your trustees should be fully aware of. Other things that I would say are important, obviously, being aware of updates, changes to the law and good practice. Also, stepping back, regularly reviewing perhaps your school policies to make sure that they are regularly updated. Now, the third duty that I would just flag up to you is that your trustees must, of course, always act in your school's best interests. So what does that actually mean in practice? Well, that means avoiding conflicts and not receiving any benefit from your school unless it's properly authorised. Trustees also need to make sure that they manage your school's resources responsibly. So what that means is that your trustees must act reasonably, honestly, ensuring that assets are only used to carry out your school's purposes. So that means that your trustees need to avoid exposing any of your school's assets or reputation to undue risk. Also, just to flag up here for academies, obviously you need to ensure that you comply with any specific requirements in the Academy's financial handbook in terms of spending funds and perhaps the sale of school land. Moving on to a further duty. So a key duty for trustees is to act with reasonable care and skill. Now, your trustees must take appropriate professional advice when necessary and give enough time to their role. So that means regularly attending meetings. Your trustees also need to ensure that your school is accountable. So you can do that by complying with statutory accounting and reporting requirements. Now I'm going to move on to, sorry, can we look at the slide, please, that's trustees decision making? I think that may be, right, yes, no, we've got that, that's great. Right, so when trustees make decisions, trustees need to ensure that they always act in good faith. They need to be sufficiently informed. They need to take account of all relevant factors, ignoring any irrelevant factors in their decision making. Trustees should deal with any conflicts of interest and make sure that any decisions taken are within a range of decisions that a reasonable trustee body can make in the circumstances. Now, obviously, I appreciate you can say, well, that's quite vague, but in a way, it's actually quite helpful because it does give your trustee board a wide remit in terms of making a decision. It doesn't mean that a decision is wrong just because another trustee board could come to a different decision, but it's just going back. Have you considered all the relevant factors and have you acted reasonably so you can evidence why you've actually come to a particular decision? Some other points that I would actually make at this stage is, and this, I think this is increasingly important in this day and age, is to ensure that your trustees do regularly review your governance structure, and particularly your appointees. So it's obviously increasingly important to ensure that your trustees have a wide range of skills, be it business related, legal, accountancy skills, HR, just to ensure that forms part of your governing body, and that you bring in people from different backgrounds with different experiences that can obviously add to your overall decision-making process for your school to help you reach the best decisions for your particular school. Now, it's clearly important that trustees have to collaborate together, work together in terms of reaching decisions, but trustees shouldn't simply defer to the opinions of others. That wouldn't be fulfilling an individual trustee's duties if they did so. What we would recommend is that any trustees that disagree with a decision should ask for that disagreement to be recorded in the minutes of a meeting. Now, one thing that I thought I would just touch on briefly today is what happens if you've actually got a trustee where there are difficulties, awkward trustee, you need to actually think about removing them. What can you do? How can you go about doing that? A few things for you to consider. Firstly, is that trustee still eligible to be a trustee? You may want to look at things like have they actually passed any recent DBS checks? Look at what it states in terms of eligibility in your Articles of Association. It may be the case that your trustee can be removed by a person who appointed them. If all else fails, however, I would just refer you to the Companies Act provisions. We can provide more details of this if it comes to it, but essentially a trustee can be removed by members. However, there are particular notice provisions, and it's important that those are complied with. Now, moving on to the next slide, please, which is about COVID guidance. Now, the COVID guidance was brought in the past year by the Charity Commission. Hopefully you're all familiar with this. This has been recently updated, and essentially the reason why it was brought in was to try and give trustees in your schools a degree of clarity and flexibility, most importantly, I think, throughout the pandemic. So this basically, the updated guidance, it includes some updates on government financial support that's available. Also, the use of reserves and restricted funds, essentially saying use reserves first before you consider using any restricted funds. It also, and this is important to flag up, it covers holding, postponing and cancelling meetings. Now, you'll hopefully be aware that under the Corporate Insolvency and Governance Act 2020, certain specific provisions were brought in which actually allowed charitable companies to hold AGMs and other members' meetings online, regardless of your school's governing documents. Now, this was introduced to allow some flexibility where meetings couldn't be held because of lockdown. However, what I just need to flag up to you today is that those provisions ended on the 30th of March. So if you are relying on those provisions, please be aware that they're no longer in place, and you will obviously need to think about perhaps amending your governing document. That covers what I wanted to talk to you about today in terms of trustees, members, in terms of members' responsibilities and the responsibilities of trustees. I'm now going to hand over to James Morgan, who is going to be talking about how to go about reporting a serious incident.
Hi, good morning everyone. So I'm here to talk to you about reporting serious incidents. First and foremost, one of the most important things to take away today is that it's the trustee's responsibility to report all serious incidents. The reporting can of course be delegated to employees such as a bursar or director of finance and operations. That's quite common, but the actual responsibility remains with the trustees at the end of the day. You as trustees cannot pass the buck on any reporting failures, I'm afraid. This is an important monitoring and compliance tool for the Commission and generally demonstrates good governance that if a serious incident arises, and that's whether it's actual or alleged, it is dealt with appropriately by the school. On some occasions, the Commission may actually offer some advice to the trustees. That's not unusual, but usually the Commission leaves it with the trustees to deal with. It's very rare that the Commission would actually intervene and take control of the charity, but it's just to remind you that it does have the power to do this, although I haven't actually seen it happen with any schools yet. Lastly, there may be risks to other charities that are linked or connected in some other way to the one reporting. The Commission therefore just needs to know about it. Okay, so some recent trends that we've seen. The most common types of serious incident reported by schools tend to be fraud, theft, or safeguarding related issues. Recently, I've noticed that there does seem to be an increase in the number of historical abuse claims being reported, and of course, incidents relating to the coronavirus. The number of incidents does also appear to have increased somewhat, but this could just be the charities they've become better at reporting these things. I don't know. Lack of reporting is a problem, not just limited to schools, but there are issues with not doing this, which I'll come to a bit later on. Next slide, please. Okay, so these are the core reasons to report a serious incident, as stated by the Commission. So trustees must report any incident if it results in or risks significant harm to the school's pupils, employees, visitors, or others. This could include people from other schools attending for music or sports events, for example, school fairs, etc., etc. Significant loss of the school's funds or assets. The Commission has indicated here that significant could mean more than 20% of its income lost. They do bandy around a figure of £25,000 as well, but this is more so if it's led to redundancies or potential insolvency situations for the school. Significant damage to the school. This could include things such as fires, floods to buildings on site, but really more so if it disrupts the actual teaching of pupils. Significant harm to the school's reputation or business. So there may be things, certain allegations circulating in the media relating to serious incident that may be damaging your school's reputation. Again, if you don't report these things, it could cause issues for the school. It's certainly better for a school to report it to the Commission first rather than have the matter brought to their attention by a third party. Next slide, please. Okay, so reportable incidents. I've already touched on some of the main categories of reportable incident you're likely to see within the education sector. Some other significant incidents that are becoming a bit more prevalent that I haven't already mentioned include significant data breaches or losses. This could be laptops left in public places. Whoops, but it does happen. And serious banking issues, for example, overdrafts being called in, accounts being frozen, or even receiving winding up petitions. It really doesn't matter to some organisations and businesses that you're a charity. The Commission has published a non-exhaustive list of practical examples of serious incidents, and a link to this can be found on its website. It will give you an idea of what is and isn't reportable, and it's just generally quite useful. During lockdown, the Commission also produced a supplementary examples table for coronavirus-related incidents involving things such as furloughing, closure of schools. This obviously affected all schools, but it's relevant when the effects will lead to pupils not being taught and a school ultimately becoming either insolvent or highly likely to close permanently. Again, the list isn't finite. It is just a guide. Next slide, please. Okay, so you should report an actual or alleged incident promptly. Now, promptly is intended to mean as soon as reasonably possible after the incident happens or immediately after your charity becomes aware of it. I think the moral of the story here is if it's something that is reportable, do not sit on it for weeks, which can be really difficult for some schools, especially in the current climate. Coronavirus has made life hard for running schools especially, and this is probably the last thing that trustees really want to be dealing with, but it's a necessary evil, I'm afraid. Sometimes trustees are not immediately aware of a serious incident that has occurred. This is fine, really quite common. What is not fine though is when the trustees become aware of something and then do absolutely nothing or simply delays reporting it for some time. Please do not brush it under the carpet. An important point to note is that not everything is reportable. If the trustees genuinely don't believe an incident is serious, then it should be covered off in the board minutes, but it must include their rationale for not reporting. It's just another example of good governance that can be exhibited if it's ever called into question. Next slide, please. Okay, so for independent schools, there's an online form on the Commission's website. You can no longer email the Commission. There's also a checklist on the Commission's website for the type of information you'll need in order for you to complete the online form. It's slightly different for academies. As stated on the slide, you have the same reporting obligations and informations to provide, but there is no online form, and the principal regulator is not the Commission here, it's the Education and Skills Funding Agency, essentially the DfE. If you do have a serious incident report, we can assist you with the online form for independent schools or contact the ASFA on your behalf for academies. We're more than happy to help. Next slide, please. Okay, so top tips and useful reminders for you. So the online form for independent schools, it does have some drawbacks. It's quite user-friendly and you don't need the charity login details to actually complete the form. However, you cannot save your progress, which can be really annoying. This is why it's really important to go through the checklist in the Commission's guidance I mentioned, just to make sure you have everything you need to complete it in one sitting. You should not be providing a great deal in your reports, and certainly not personal or sensitive information. For example, if it's a safeguarding incident involving 2 pupils, you should just refer to them as Pupil A and Pupil B. Just enough information for the Commission to get a grasp of what's happened, how you've dealt with it, details of any other organisations or authorities that have been informed. That could be the police, LADO, for example. Any media lines set up, the policies you may or may not have in place, and what changes you may have implemented as a result of the incident happening. Now, this is what I alluded to in my earlier slides for not reporting. It's actually a criminal offence to knowingly or recklessly provide false or misleading information. There's a declaration at the end of the online form stating that you understand this important point. In short, do not withhold or hide any important documents or put them into the confidential waste bin. Okay, whether it's the Commission or ESFA, they will usually expect to be told what's happened in relation to your serious incident report. Some incidents do drag on, so it's best to submit an interim update to them. It's usually in the same fashion for to the Commission or ESFA respectively. Otherwise, for just shorter matters, a simple update of the final outcome when it's known should suffice. Last but not least, your charity must sign a declaration in its annual return saying that there were no serious incidents in the last financial year that should have been reported but weren't. And it's just to be mindful of that. I think that's my last slide. Thank you everyone for listening.
Thank you, James. That was a really helpful summary and reminder to everyone, I think, of what constitutes a serious incident and when one would need to be reported. Hopefully that scared you all enough to have this on your mind. It's a really tricky thing because there's so much going on for schools at the moment. We absolutely realise that and recognise that. And it's really difficult for you as governors and trustees to keep on top of everything. So hopefully this is just today as a useful reminder of some of the things that you need to have at the front of your minds and to think about when various things arise. And as James said, the most important thing here is it is your duty as trustees to decide whether there is a serious incident that needs reporting. So just really worth reminding yourselves of the guidance if it's something you haven't thought about for a while. So thanks very much, James. Right, so I'm going to now move on to another issue, which again could be easily forgotten and quite often is, to be honest, and that is what constitutes a material change for a school. So I'm going to begin by going through a couple of slides on a material change for independent schools, what constitutes a material change if you're an independent school, and then Emma is going to cover what constitutes a significant change if you're an academy, as the process that you need to go through is different if you're an independent school and if you're an academy. So as I've just said, you don't need me to tell you a huge amount has gone on in the last year as a result of the pandemic and other things that were already happening in relation to TBS, etc. As a result, what we are seeing is, of course, a lot of uncertainty for a lot of schools, as well as, and some opportunities, I should say, but various issues that have arisen for schools that we've noticed in particular over the last sort of year. Some schools facing financial issues, becoming under financial distress, and in particular, you may be asset rich, but be struggling on the cash side of things. And that's one of the impacts that we've seen quite a bit of. You may have seen a decrease in your pupil numbers as a result of the pandemic. And again, some of these things may apply to you, some may not. It's different for every school, but this is just some of the things we have seen and that schools are talking to us about. Some schools have struggled with international students and boarders who have not been able to come over to the UK because of restrictions. Some schools will have used, I'm sure a lot of you probably will have taken advantage and been able to use the furlough scheme in relation to the furlough of staff. There may have been redundancies made at some schools. And of course, there's been this huge change to remote learning that schools have you know, on the whole, fantastically put in place at very short notice. The other thing that schools have had to be tackling a lot recently is, and again to different degrees, but potentially an increase in parental complaints, perhaps to do with remote learning or the existence or non-existence of fee discounts, etc. What that has meant is that you as governors have had to look at your school and think, the strategy we had in place before the pandemic, is that still the right strategy? And that's the question you certainly should be asking yourselves. The strategy we had in place before, is it still the right strategy? And what that may lead you on to is considering making changes to your school. And in some cases, these changes may be deemed a material change. Next slide, please, Lisa. So what do I mean by a material change? So the Department for Education lists 7 changes that you may make to your school that constitute a material change. So I've listed them here on the slide, and just to run through them briefly, a change to your school address. So if, for example, you were looking to change the site of your school for some reason, that would be a material change because it would be a change to the school's address. A change to the proprietor. This is a potentially more obvious one. So if you were to merge with another school, or if you were to sell to a commercial school group, for example, to join a larger group, which there is quite a bit of that going on at the moment, that would be a change to the proprietor. So what we mean here is a change to the actual owner of the school itself. So, and that would constitute a material change. Other material changes are change to the maximum number of registered pupils, a change, adding or removing boarding facilities. So if, for example, you're currently a day school and you decide the way to future-proof your school is to become a boarding school, you're likely to do 2 things. You're likely to increase the number of registered pupils, and you are obviously now becoming a boarding school. So there immediately are 2 material changes. The other material changes that you may carry out are changing from being a single-sex school to a co-ed school, so again, that immediately is a material change, and something you might consider at the moment with everything going on, if it's something that you feel would benefit your school. Changing the registered age range of the school. So for example, if you were to introduce a nursery or a preschool and you don't currently have one, or perhaps you're a senior school and you merge with a prep school. So there immediately you have increased the age range of your school. And then finally, if you were to admit 1 or more SEN pupils. So you can see there are quite a few things that you may be considering doing that would actually constitute a material change for DfE purposes. Next slide, please. So what does that mean? What it means is before you implement the change, you need to get DfE approval to the change. Now, I've underlined before on this slide because this is really important. What we are seeing a lot of is schools either not realizing that the thing they're about to do constitutes a material change, or thinking that they could do it and get consent post-implementation to the change. The guidance from the DfE is very clear. If you are going to do something which constitutes one of those 7 material changes, you must make an application before you implement the change to get consent from the DfE to make the change. So what that means is in reality, you have to get their prior approval in order to do what it is you want to do. The DfE have the power to either approve or reject the proposed material change. If it's rejected, it may be in whole or in part. So they may say, this part of what you're planning on doing is fine, but we don't like this. Quite often, if there is any part of it that's rejected, they will put an action plan together and say, you need to do these things. And if you do, at that point, we can then approve the change. So for example, if you were looking to go co-ed, you're currently single sex, you're looking to go co-ed, I'm going to use a silly example, I'm sure this wouldn't happen, but let's say you hadn't put in place boys' toilets at a currently all-girls school, they're likely to reject the application and say you need to put those in place, and once you do, we will then approve it. So that's just to use a very obvious example. Failure to obtain prior approval in a worst case scenario can result in the school being removed from the DfE's register, which obviously is a catastrophic consequence. So it really is important to get this approval before you make the change. How do you get the approval? You go on the DfE's website. I've included the link here. As Emma said, we will be sending the slides around after this, so you don't need to worry about trying to take too many notes down. So the link is there on the slide. It's actually a pretty friendly application form. It's much easier to use, I would say, than the serious incident reporting form. I think James would agree. So you can download it, you can save it, go back to it later. Once you've completed it, you upload it to the DfE's back onto the portal. I would say the more information you can give, the better, to explain why you're making the change and the thought process you as governors have been through and the things you put in place in order to implement it. When you make the application, you're likely to get an automated response that says, we'll get back to you within 3 or 4 months. That's what we've seen in the last week with a couple of applications that we've put in. Don't panic. Hopefully you will hear back quite a long time before that, but it does depend on a couple of things. Of course, how busy they are at the time, but also the change you're proposing to make. So if it's quite a simple one, the likelihood is you will hear back quicker than if it's something a bit more complicated that involves more change. It's important to note that when you put your application in, it automatically triggers an inspection. Now, whether the inspection actually occurs, again, depends on the change you are planning on making. So if it's a pretty simple, straightforward change and it won't really have much of an impact, so let's just say your numbers are increasing by a small amount because you're actually recruiting more pupils, then it may be that an inspection is not felt necessary by the DfE, and instead of an inspection happening, they will simply review the information you sent them and then give their confirmation, their approval. But if an inspection is required, that inspection needs to happen. It's usually the ISI. They then report back to the DfE on their findings, and then the DfE will give you hopefully their approval or come back to you with any steps that need to be taken in order to get their approval. So as I say, in practice, it depends on the type of material change being proposed as to how long this takes. But just before I hand over to Emma, I do want to stress it's really important to think ahead about these things. So what we are seeing a lot of, as I say, is schools who have announced they are planning on making changes. So for example, going co-ed from being single sex, or restructuring their current schools if they've got several onto one site, and they're making that announcement before they get the approval. And of course, that is then putting them at huge risk of that the DfE will not approve the change. So what you need to do is think ahead. When you are considering making these changes, get your application in early to the DfE, get their approval, and then you can make your announcement to staff, stakeholders, and all other stakeholders and pupils with confidence that you know that you have your material change approval. Great, I'm going to hand over to Emma, so we just need the next slide, please.
Thank you, Kate. That was a really helpful overview for the material change process for independent schools. I'm going to talk through now the process of making a significant change if you're an academy. Now, the DfE published guidance on this about 18 months ago now, I believe. What I would say, and I would reiterate what Kate has said to you in this session, is it's really important to be aware of this guidance before you actually make any changes. So if you've gone ahead, you certainly wouldn't be the first school to do so, but much, much, much better, and obviously what you should be doing is to be aware of this guidance first of all, to understand what actually is a significant change, which I have to say is not always particularly clear, and then to follow the correct process. So a significant change is essentially defined as any change which will have an impact on the number, type, and or location of school places at your academy. Now, just to reiterate, if you're proposing to make a significant change, you must submit a proposal for change and follow the required process in advance of any change being made. If you don't, you do put yourself at risk, and you could find your school in a situation where you effectively have to unravel any changes that you've already made. So an application that you make to the DfE can either be fast track, or it may require a full business case, and that depends on the specific change that you're looking to make, and I'll come on to that in more detail. For any proposed change, there must be local consultation where you give consideration to the potential impact of those changes. Now, one point I should just flag up is that if you're making an application, if you're wanting to make essentially governance changes, so I'm thinking here of a single academy trust joining or becoming a MAT, please just be aware that this particular guidance isn't relevant here. So in those sort of situations, you need to follow the traditional conversion process. So moving on now, if we can look at the next slide, please. I'm going to look specifically now at fast track applications. So for your school to be able to make a fast track application, which essentially is, it's an easier, more straightforward process. To be eligible to make such an application, your academy needs to be rated as good or outstanding. Your most recent Progress 8 score should be at least the national average, and your school needs to be in good financial health. Now, your academy will also need to provide evidence that your local authority does not object to the proposed change. So that's just to flag up. It's important that basically you engage and you ask questions, you talk to other people who may be affected before you even get to the stage of submitting an application. Now, some of the changes which can be fast-tracked include, if your academy is thinking perhaps of adding boarding provision, if you're looking at increasing the capacity of your academy. However, there is an exception. There are lots of exceptions here, just to be aware. So it applies if you're increasing the capacity of your academy, but with the exception of if you're setting up a satellite school. It also can potentially apply to age range changes of up to 2 years. However, there's an exception if you're adding or removing a sixth form. So moving on now to the next slide, which is the full business case. So essentially, just in summary, if the change that you're looking to make doesn't meet the fast track criteria, that's when you need to make a full business case application. So the sort of situation that I'm thinking about here is if your proposed change may be considered to be contentious. In those sort of situations, a full business case will be required, and that's irrespective of your school's Ofsted rating. So the sort of examples that I would give where you need to go down the full business case route are if objections have been received that the proposed change could potentially undermine the quality of education provided by other good or outstanding schools in the area by creating additional places where there where there is surplus capacity. Also, another situation where a full business case is relevant is if you're changing the number of pupils in a special school, where the increase is either 10% or more, or 20 pupils or more, and we're looking there at whatever is a smaller number. In addition, where you're changing the lower or upper age limit of your school by 3 years or more, that will require a full business case. So moving on now to the next slide. What this looks at the process that you need to follow. This is obviously set out in more detail in the guidance, but for the purposes of today, I would just like to give you an overview and flag up some points for you to be aware of. So in terms of the process, to carry out what you need to do is to carry out a fair and open local consultation, and that needs to be over 4 to 6 weeks as a minimum. Now, if a significant change does not require a variation to your school's admission arrangements, the consultation should run for a minimum of 4 weeks. If, however, you're making a significant change that requires a variation to your admission arrangements, so I'm obviously thinking here perhaps if you're planning on extending the age range and say opening a sixth form, in that sort of scenario where you will need potentially a variation to your admission arrangements, it's important to be aware that you need to consult for 6 weeks. And what the recommendation is, and what we would certainly suggest, not least to make the process more streamlined and straightforward, is that you should run concurrently your admissions and significant change consultations. Now, other points just to flag up as part of the process. You need to ensure that you have funding in place for any changes and that you've obtained any relevant planning permissions or other consents. You also need to obviously think about whether there will be any negative impact on other local schools. You should then submit the proposal using the DfE's inquiry form. And in terms of timescales, it's important to be aware that you should make this submission at least 3 months before the proposed change. Now, 3 months is required here to ensure that there's enough time both for the decision to be made, but also for you to implement changes. So that's in terms of, in all likelihood, there will be changes that will be needed to your school's funding agreement and also potentially to your admissions arrangements. Now, who is it that actually makes the decision? Well, ultimately, in many cases, it's going to be the regional school commissioner who will decide whether or not to approve your proposal. However, and there is a however that we've come across in a few situations, this tends to apply particularly in a situation where a change is likely to be very controversial. In those sort of scenarios, the RSC may decide to actually refer this back to the DfE. So effectively, they're escalating any decision on the proposals and it will be referred to the Secretary of State to make a decision. Now, what I just want to flag up to you is the importance of following this process. As Kate indicated, there would be implications if you don't follow the process. So for an academy, if you don't do so, there is a risk that you could be considered to be in breach of your funding agreement. So what I would say is, if you have any questions about the process, then by all means, get in touch, ask those questions initially before you start off going down that route. I hope for today that's given you a good overview of the process, but obviously, as we've said, we're very happy to answer any questions, and please do feel free to submit them in the Q&A function, or of course, if you come back to us afterwards, then we'll be very happy to answer any further questions. Now, what I'm going to do is move on, if we may, to the next slide. So for the final session today, Kate and I are going to be discussing a case study. In it, we're going to be looking at the potential benefits for you of incorporation, so incorporating a charity. Now, in this scenario, this is essentially a scenario that may arise for your school if your school is actually unincorporated, or possibly, and I'm thinking about what may be a more likely scenario for you, is where you have an unincorporated charity that's actually associated with your school. So what we're thinking about here is, if perhaps you have, say, you're an independent school and you have a foundation charity that's associated with your school. This could be a foundation that perhaps appoints trustees to your governing body or makes grants to your school. That may have been established many years ago as an unincorporated charity. Other scenarios, and it's important because I think it's one area that people perhaps aren't completely aware about, and they're not necessarily aware about the implications of having an unincorporated charity. So where this could apply, if we're thinking about, say for state schools, what I've seen is a situation where you may have a school that has established a charity, perhaps alongside other schools, and they may have established this to provide perhaps off-site residential provision and activities for maybe students and the wider community. This may have been established many years ago and set up as an unincorporated charity. So those are the sort of scenarios that Kate and I and the rest of our team come across, and these can be problematic. So we thought it would be helpful today just to talk you through the implications here. So probably just as a starting point, what does it basically mean to be unincorporated? Well, what we're talking about here is for an unincorporated charity, usually it may be established perhaps by means of a trust or a scheme. So what it wouldn't be a body such as a company, but it could be, we would still expect it to be registered with the Charity Commission. Now, the sort of problems that you're likely to come across here are that the governing document, as I've indicated, may have been put in place many years ago, potentially hasn't been updated. Also, you can find that you may run into difficulties if perhaps as circumstances change, you find that the trustees now wish to try and obtain perhaps a bank loan or maybe acquire some nearby land. So what I'm going to do now is to look in a little more detail, and if we can move on to the next slide, please, at some of the reasons why you may want to consider restructuring an unincorporated charity. So I think probably one of the most important reasons to flag up to you today and for you to take away is that to do so will help to limit the personal liability of the trustees and members. So incorporation effectively gives limited liability. Other points to think about are that also any future borrowing from a bank will be simplified. So banks will readily recognise traditional corporate structures. It makes things easier in lots of different ways. So for example, just needing two directors to sign documents. And your individual trustees will not be personally liable for any bank loan. Other points to think about, so in the property context here, property would then be held by a corporate entity rather than your individual trustees. So this will make transferring property much easier. It would also be simpler if you have an incorporated charity. It would also be far simpler overall to manage your charity's business and to enter into contracts. And finally, a further point just to flag up is it's also probably a good opportunity to be able to modernise what may well be an out-of-date governing document. Now, what I'm going to do is just move on now, if I may, to Kate. So Kate, in this sort of situation, it would be really good to know what you think, if you find, and I know you do all the time, if a school asks you for advice in this sort of scenario, what would be the potential new structures that you would think about and suggest to a school in this situation that they may want to consider?
Thank you, Emma. Lisa, can I have the next slide, please? Perfect. Yes, thank you, Emma. So if, having gone through the thought process that Emma's just spoken about, you as trustees, governors, think to yourselves, okay, yes, we need to, there are very good reasons why it would be worth us considering incorporating, and you make the decision that you want to potentially incorporate, what structures could you use, as Emma has said? So there are two main structures that I'm just going to cover briefly. So the first one is a company limited by guarantee. So this is the structure which I think it's fair to say is the one that is most commonly used by schools if they are looking to incorporate. I say that, I should caveat that by saying if it's the main charity that's going to be operating the school. So the reason for that is a company limited by guarantee is suitable if your charity is quite complex and it's going to be, for example, entering into contracts with third parties, if it holds property, if it potentially is going to want to borrow money from a bank, as Emma touched on, then a company limited by guarantee would usually be our advice for the best structure to use. It does depend on individual circumstances, and it would always be, we would always advise each school on an individual basis on the facts that are presented to us. But it is most likely that a company limited by guarantee is going to be the suitable one if there are lots of things going on, which many schools often, of course, there are. The reason for that is it's widely recognised by third parties. So banks, for example, if you are looking to borrow money, they will want to review your constitution. They will often ask us, if we're acting for you, questions about your setup and structure. And one where you are a company limited by guarantee is one that they readily recognise. So if you are a company limited by guarantee, if that's the structure you choose to become, the constitution that will be put in place is articles of association. So you will be a company registered at Companies House, and which means that you will be governed by filing requirements and fee payments at Companies House, as well as the Charity Commission, and your constitution would be articles of association. You would have directors, so the trustees would also be directors of the company. It's the same people, so they're all the ones. So the same person would be a governor, a trustee, and a director. As Emma touched on earlier, they would all be the same people, and they would be the ones managing the business of the company on behalf of the members, and in effect running the charity. The key advantage of incorporating, one of the key advantages of incorporating, as Emma has said, is members, is limitation of liability for you as members. And just like in relation to a CIO, which I'll come on to next, if you are a company limited by guarantee, your liability as members is limited to usually £1. It's the amount that is put into the constitution, and it would usually state £1. I should make the point that there are exceptions to that, as is often the case in law. And if, for example, there was found to be fraudulent activity or gross negligence of the trustees, then there is a possibility that that limitation of liability would fall away. But on the whole, you benefit from the limitation of liability. So I think we'll move on to the next slide, please. And I will just briefly run through the alternative, which is a charitable incorporated organisation, the main other alternative that you may consider. I wouldn't rule this out. It is definitely worth talking to us or your legal advisors about, as I say, the structure to use, because it does depend on your circumstances. And as Emma has said, there may be different circumstances as to why you are considering incorporating. A CIO, these structures came in, I'd like to say about 10 years ago, I think. There was a lot of excitement when they first came in. The reason being what they provide, and there are some advantages to them, because what they provide is a separate legal entity for a charity. And so they provide the limitation of liability for you as trustees, but they are a simpler structure and they are not registered at Companies House. So there are no Companies House filing requirements or fee payment requirements. And so for that reason, quite a few charity trustees feel that they are a simpler structure and one that is easier to deal with. That is correct, but they, I would say, are suitable for smaller charities. So if, as Emma mentioned, you have within your overall structure, let's say a small charity, it might be, it may have been set up for the PTA or some other organisation within your school structure, then a CIO may be suitable. But I would say if you have got, if you're talking about for your main school setup, for example, and if there is property involved, or banking arrangements involved, so you're going to potentially want to borrow money to take security, put security in place over your assets, then a CIO is less favourable in our experience and from what we see. Mainly because, as I say, banks, etc., are often a little bit nervous of it. They don't really understand it, and it just doesn't seem to lend itself to a more complex structure. But if you've got a simple sort of a smaller, simple charity that doesn't have a lot of other things going on, then a CIO could be a really good option. So it does depend on your individual circumstances. Next slide, please. So what I thought I would do to just finish off this presentation on why you might want to incorporate is talk you through, if you've looked at your current setup and decided that you do want, and you are unincorporated, and you've decided you do want to provide the trustees with that limitation of liability and make it easier to borrow money, to enter into property transactions, etc. And for that reason, you've decided to incorporate. How do you do that? So the first thing you would do is talk to your legal advisors. It's quite a big transaction, this. That's something I should say. It's not something you're going to do in a month. Unfortunately, at the moment, there is no charity law that enables you to go from being an unincorporated charity to an incorporated one overnight. That would be really nice. and we continue to hope that that may happen in the future. Unfortunately, that isn't the case right now. And so what you have to do is you have to set up your new incorporated entity. So the ones we just discussed, most likely either a company limited by guarantee or in some circumstances CIO. And what you then have to do is transfer over all of the assets from your current charity into this new entity. So for that reason, it's not something you're going to do lightly. You are going to think about it seriously. But if, as I say, there are lots of reasons why it's a very good thing to do, especially at the moment with schools wanting to borrow money, etc. If you've made that decision, then what's the process? What's involved? So what you would do is the first thing you would do is speak as a group of trustees and members. You would convene a meeting, an EGM, to make the decision to resolve to go ahead with the restructure. And then having done that, the next stage is having spoken to your legal advisors, taken advice on the best structure to use, you would then set up your new structure. I'm going to assume for these purposes that it's a company. So the next thing we would do is form the new company. So what's involved there is forming a company that is registered, setting up a new company at Companies House. That's a very simple thing to do. The more complicated thing is we would need to put in place your new constitution, so new articles of association to govern that company. So what we would do is work with you, looking at your current constitution, deciding which bits of your current constitution you want to keep and you need to keep, including those in your new articles. And then we would use this, as Emma said, as an opportunity to update your current constitution. So for example, if your current constitution does not allow you to hold meetings remotely, this would be a great opportunity to include that provision here. So it would be used as an exercise to update your current constitution, as well as move across the important provisions in your old one. So setting up a new company involves getting it registered at Companies House, getting the new articles drafted, and working with you to make sure that they are reflect the way the charity is going to work and operate going forward. Then at that point, we make the application to the Charity Commission. And this involves an application to the Charity Commission where we would explain the reason for the restructure. We would explain what we're doing. We would include a copy of the proposed new articles and your resolution approving the restructure and approving the new articles. And then all of that would go off to the Charity Commission, seeking their consent to this proposal. A couple of things that are worth thinking about that make things slightly more complicated sometimes. You need to consider the property that the charity currently owns. So is it freehold property? Do you have any unregistered land? Do you hold land under a lease or a license? So all of those things are really important to identify early on, so that we or whoever your legal advisors are can advise you on how those things will need to be dealt with when transferring them to the new company. Banking always gets forgotten, and it always takes the longest to set up a new bank account for some reason. So really worth thinking about at the beginning. When your new company is set up, you will need a new bank account to transfer all of your banking arrangements into. So something that's just a practical point is get on top of that early on. Always take tax advice on if you're considering excuse me, a restructure in this way. Always speak to your current accountants or whoever you wish to use to make sure that there are no tax implications of what you're considering doing. And then the last point, which is really the most complex one, is the business transfer. So as I say, unfortunately at the moment, the only way to do this is we transfer all of the assets from your current charity into the new company. So what that means, that's quite a big exercise, really just for your legal advisors to think about and work with you on, because what needs to happen is there needs to be a review of all of your current assets. So as I've already touched on property, we would need to look at your current contracts. So for example, do you outsource your catering? Have you got a catering contract that would need to be assigned? Because all of these contracts need to be assigned, transferred to the new company. So it involves some due diligence where we need to review the term, we or you or together need to review the terms of your contracts, your supply agreements, and just determine whether they can simply be assigned without needing consent, or whether we need to speak to third parties to gain consent at the right time to transfer these over to the new company. So it's very similar in a way if you're selling the assets of the school, because it's the same idea, which is you're transferring them to a new entity, but it's obviously simpler because you haven't got a third party involved. So those are the sort of things that need to be considered. So staff is obviously a key factor with the business transfer, because they will transfer over under something called TUPE. And again, there are certain procedures that need to be followed at the right time. So it's just important to note that it's quite a complex procedure, but one that it's more about following the steps in a certain order and doing things at the right time to make sure that it all happens as it should. So just in relation to a couple of pre-completion matters to consider before I finish off. So as I said, timetable wise, because of the amount of work involved, I would say it probably is fair to allow, say, 12 to 18 months to complete this from start to finish. I'd like to hope it could be done in 12. It's always a bit of an unknown with the Charity Commission as to how long their consent will take to get. So that's why we tend to say 12 to 18, but hopefully this could be done in sort of 12 months from start to finish. And something to note, I should have left this off and put this as a question to see how many of you had been listening. This should have been a test. So what we've got here is a material change, which to me is not necessarily that obvious. And this is a really good example of how these things can easily catch any of us out. So what we have here is a material change because we are in effect having a change of proprietor. So even though you've not got a third party coming in, you are changing the owner because you are going from an unincorporated charity to an incorporated one, which is its own legal entity. So you will need to apply to the DfE before this is implemented to get their consent, which obviously this is a procedural issue. It shouldn't be a problem, but it is a step that needs to be taken. And then just very briefly to finish off, few other things to think about post completion of the potential incorporation is, again, from a legal point of view, this would be deemed a merger because you are transferring assets from one charity to another. And so therefore you do need to notify the Charity Commission afterwards that a merger has occurred because they have a register of mergers. If you have any foreign students and you have student visas in place, what used to be referred to as Tier 4, that's really important to consider early on, and the potential transfer of that visa or application of a new one needs to be considered, and there will be post-completion obligations in relation to that as well. And then lastly, the likelihood is you're going to want to dissolve the current charity. Not always, again, it depends on the reasons this is happening, but you may want to dissolve the current charity. So that's something that is often occurs once all of the assets have been transferred to the new entity. Right, so I hope that and all of the presentations this morning have been helpful. We've realised that we've just tried to highlight a couple of things that we are seeing, that we are getting asked questions on at the moment, that we thought it would be useful to run through with you. What I'm going to do is ask if anyone has any questions that they would like us to address now on this forum. I'm just checking the time. We've got 10 minutes left, which is perfect. Oh, and I can now see my fellow speakers, which is great. So we've got Emma and James, and we've also got Coral. I'm hoping you can all see Coral. And so Coral works with us all in our education team as well. So she's joined us to just help with any questions, which is fantastic. So I'm just going to have a quick look at our Q&A box. As I say, as Emma said, please do put any questions in there if you've got anything you want to ask at the moment. Otherwise, you can always contact us afterwards. So I'm just picking up 2 questions here. Oh, this is a good one. Okay, someone's on the ball. So yesterday, the Charity Commission announced some forthcoming updates to legislation. That's absolutely right. Are you able to give us any information about what these updates are, please? Brilliant. Great question. And luckily, we have Coral, who has been tasked with looking at this for us. So that's great. So Coral, would you mind just giving us a really brief answer to, there were a couple of key things, I believe, that are potentially going to be changed. So if you wouldn't mind just giving us a brief answer to that, that would be great.
Absolutely. So there are 5 areas of change which have been announced, which are hoped to make life simpler for trustees. The first of these changes is that charities and trustees will be able to amend their governing documents or royal charters more easily, although of course this will be subject to approval in certain circumstances. Second update is that charities will have access to a much wider pool of professional advisors on land disposal and to more straightforward rules on what advice they must receive. And this is hoped to save them time and money when selling land. Thirdly, charities will have more flexibility to make use of a permanent endowment. This includes a change which will allow trustees to borrow a sum of up to £25,000 of the value of their permanent endowment without the Commission's approval. Additionally, trustees will be able to be paid for goods provided to a charity in circumstances, even if this is not expressly stated in the charity's governing document. The current situation is that trustees can only be paid for supply of services. So this will give charities flexibility to access goods from trustees when it is in the best interests of the charity, for instance, when it's cheaper to do so, and they won't need permission to do this. And finally, they'll be able to take advantage of simpler and more proportionate rules on failed appeals. For example, if a charity appeal raises too little money, the charity will be able to spend donations below £120 on similar charitable purposes without needing the permission of individual donors to do so.
That's brilliant, Coral. Thank you so much. So there you go. So hot off the press. Couple of potential changes that are coming in, which I think are brilliant, and what it's showing is the Charity Commission is the Charity Commission is really excited about this, and I think it's giving trustees the ability to get on and run the charity and do their job while still keeping the oversight needed, but actually just giving them a bit more flexibility to make life for the trustees simpler and to make it easier for them to maximise the benefits, in our case, for pupils. So that's absolutely brilliant. So a couple that I'm particularly excited about is I'm really keen to see the relaxation rules in relation to the sale of land, because I know for many schools that could be that's quite relevant. Schools may be looking to sell land if they're looking to raise extra money, or if a school is looking to potentially sell or merge with another school, then the sale of land becomes really important. So it would be really interesting to see what those changes actually are, and again to be able to potentially use some of the permanent endowment and for a royal charter to be able to make changes hopefully in a simpler way. So we will absolutely wait with great excitement to see what the proposals are that come in, and we will, of course, what we'll do is produce a note on those. When we have more detail, we'll produce a note on those and circulate that to everyone. So that's really exciting. Thank you, Cole. That's brilliant. Okay, I'm just having a look. We've got a couple of other questions. So I've got, if our articles do not currently allow meetings to be held remotely electronically, can we do so anyway? So I can answer that one, and then anyone else jump in if they need to. But in relation to that, so the COVID guidance that Emma spoke about earlier, that was put up on the Charity Commission website in the middle of the pandemic, very much relaxed these rules, and the Charity Commission took the view that even if your articles, your constitution doesn't allow you to hold meetings remotely, you can do so because of obviously everything that was going on. What they've done is they've said that the rule is not quite as relaxed anymore. So what they have said is you do need to now go back to look at your articles to see if it allows you to hold meetings remotely. If it doesn't, and one of the key things to check, sorry, is whether it prohibits you from running them remotely. If your constitution does not expressly allow you to, then as Emma said, our advice is to, if possible, amend it as soon as possible so that you can hold meetings remotely. What the Charity Commission have said is, if you currently are not able to hold them remotely in your constitution, and for some reason you can't amend them, they will allow you to, and if you say, well, we can't hold our meetings in person, so we have to hold it remotely, they will allow you to do so, but they want you to document your decision to do that, and so that it shows good governance. So the upshot is, it's not as relaxed as it was. Please do amend your constitution if at all possible to allow you to hold meetings remotely. But if for some reason you can't and you desperately need to hold a meeting, then you can, but you must document the fact that you've done that and that you are aware that your constitution doesn't give you the express permission to do so, as that just shows good governance. Does anyone else have anything to add on that one? No. Okay, that's perfect. Well, I think unless anyone else has any burning questions, we've got a couple of minutes to go. So there's one other question here, actually, sorry. Is there a limitation on the length of time an individual can be a member? In other words, can they be reappointed on a number of occasions? Emma, I don't know whether this is specifically for an academy or just a general question.
Right, shall I? I'm happy to jump in.
Yes, if you're happy to jump in, yeah.
And try and answer that. So, okay, that's quite an interesting question. So what we would usually expect to see, and obviously this is all going to be very much dependent on your school's articles of association. What I would usually expect to see is that actually it's in relation to trustees where you may see some limitations. So the sort of things that you may see is that perhaps there's a 4-year term. It could be, and it may not even be in your articles of association, but certainly for, particularly for academies, it may just be a question of good practice as to whether you consider that trustees should perhaps be appointed for a maximum of 2 terms, so 8 years. So that's the sort of scenario where I would usually expect to see limitations on terms. Thinking specifically, the question I appreciate is obviously about members. I have to say I haven't seen any particular restrictions, though please, Kate, James, do jump in, particularly for independent schools if you're aware of any. So what I would usually expect to see is that a member is appointed, but then effectively in terms of removal, it may be the case that they simply resign, and or there are what you would expect to see is there will be provisions in place so that that member can be removed. So I suppose you could then effectively say, for any number of reasons, be it to do with a set term that you have in mind that will be appropriate, it may be the case that the other members could then intervene, agree by means of a resolution that they're going to remove a particular member. But I have to say, in answer to that specific question, I haven't seen specific terms inserted within articles of associations in relation to members. But I don't know if you have any further comments there, Kate.
No, that's perfect, Emma. No, I agree with you. And no, yeah, I think you're right. The only thing I'd say is what you said at the beginning, which is so certainly for independent schools, most of the time, not always, but most of the time, we find that the members, there's a limited membership, so the members are the trustees. So exactly as you said, you then look at it will be more so that your term is limited as a trustee. you should really be limited as a trustee for good governance in your constitution, which in effect limits your time as a member, assuming that the members are the same people as the trustees, which in an independent school is usually the case. So yeah, I agree, Emma. We're just going to wrap up, but I've just got one question one final question that's come in from Paul Rennick, who has said, in respect of financial changes such as overdrafts or borrowing, is there any guidance as to when these may need reporting to the Charity Commission? Paul, I'm going to assume, it's difficult because I can't see you, I know, I'm going to assume you mean reporting in respect of a serious incident report. I think that's what you mean. If it isn't, I apologise. I absolutely will pick this up with you afterwards, but just to briefly answer the question, because it's a very good one. And yes, there is specific guidance from the Charity Commission on financial issues. So there is some specific guidance that was included in the COVID guidance, as it were, on financial issues. So it could be there's something in there. And then in relation to the making of a serious incident report, there may be something specifically in that guidance. So what we'll do, Paul, so I think the short answer is yes, there probably is something that hopefully gives a bit of guidance as to when would be the time to potentially need to tell the Charity Commission about financial issues. And we will, what we'll do is, Paul, is try and send you those links after this, if any we can find. I mean, what I would say just generally in relation to the financial position of the charity, the most important thing to do as governors and trustees is keep an eye on your general position in relation to your finances. And if you feel you are getting anywhere near close to a situation where you worry, you know, in a worst case scenario, you worry about potentially running out of cash, being in financial distress, you need to act on that as a group of governors early, look at the options, if necessary, consider whether a serious incident report is required, but talk to people that can support the school and think of what you can do to try and rectify the situation, or to try and act in order to protect the school going forward. And that's something that we as legal advisors can help with, your accountants would be able to potentially help with, etc. So acting early in those circumstances is really important, and just looking at the options that may be available to you in order to future-proof the school, as I mentioned. Okay, well, I think we've gone a minute over, so I apologise for that. Thank you so much to everyone for attending this morning. We hope you found it useful. As we've said a few times, just an overview of a couple of topics which we think are particularly relevant at the moment and just worth reminding everybody about. Don't hesitate to pick up the phone. These are not always easy things. To know what to do about them. We're very happy always to have a quick conversation, talk it through with you, and confirm whether or not you need to take any further action. That's never a problem. Emma acts on the Academy side of things, and Coral and James and I on the independent school side. So do pick up the phone to any of us, or drop us an email with any questions you've got following today. And as Emma said at the beginning, we will send out the slides as well. So hopefully that will act as a bit of a memoir going forward. Thank you very much, everyone, for attending.